For reasons mentioned in the judgment, the charge sheet number 73/23 dated 30/3/2023, which was laid in Hojai PS case number 81/23 is hereby quashed. Consequently, the proceeding of special POXO case number 72H/23 pending in the court of learned Special Judge Hojai is also quashed.
May it please your lordships. Lordships, in this case, the petitioner has been shown arrested in connection with Hatigao PS case number 86, lordship, on 21/5/2024, and as on date, he is behind the bars for 36 days, or 56 days. 56 days. And the allegation under which he has been booked is section 380 IPC. Lordship. The affair is at
Where
page
is the affair?
10, lordship. Page 10, lordship.
Yes.
It is alleged that while the informant was the second paragraph, as have been reported by my wife, most of her gold jewelry, that includes so and so, so and so, so and so, have been stolen. We are still trying to figure out if other valuable apart from gold jewelry have been stolen. So me and my wife stay in Rani and visit our residence every week.
What is your submission?
My submission is that, lordship, I was originally arrested
When?
on 8/5/2024 in connection with Hatigao PS case number 87, lordship. And while I was behind the bars, I have been arrested in 2 other cases, out of which this one and another is Posisto 287. That is also listed before court number 22 today. So in this case, nothing has been recovered from me, lordship. I have been throughout in the judicial custody. That apart, several remands have been taken by the police.
Police remand.
Yes, lordship. The police remand was taken in 87 as well as in this case also, lordship. Kindly the page number 17 may be perused, lordship. Page number 17. With reference to the subject cited above, I have the honor to pray that I am returning here with the following accused persons who were brought in police custody on 22/5/2004 for 2 days. On 21, they were shown arrested. Thereafter, they were taken to remand, and thereafter they are returned. Now, lordship, and in this case, another co-accused, lordship, page number 18, lordship. Your lordship has been pleased to release the accused, Shiraz Ali, who has been arrested in connection with this case also as accused number 1, page number 15. He has been listed as accused number 1, Shiraz Ali. That Shiraz Ali has been granted bail by your honor's court, lordship, your lordship's court, on 19/6/2020.
No, it was by a coordinate bench.
Lordship.
He was released by a coordinate bench of this, not by me.
Oh, no. Yes, sir. Page 21, lordship. I'm sorry, lordship. Page 21 is your lordship's order. Page 21. Page 20. I'm sorry. Page 21 on 19/6/2024. While actually he was behind the bars for 23 days, lordship. After 23 days custody, your lordship was placed to 27 days.
Yes, 56 days. He
My lord.
56 days.
My lord,
And in 87, he has been granted bail on 2/7, lordship, by
from his
Understand.
submission, it reveals that he is the, my lord, habitual offender. Several cases are against him, my lord. as per my lord.
Lordship,
But
shown arrest in
from-
the fashion of this day,
My
Lord.
lord, from the my submission is the lordship may fix tomorrow or day after tomorrow, my lord. I'll produce the case there, my lord, to find out his role are different, my lord. See, it is there, my lord, but their role may be different,
Tomorrow you can bring the case diary.
my lord, from Hatigao.
Hatika, only.
Okay. Then
Day after tomorrow, my lord.
day after tomorrow.
My lord.
Heard Mr. Zaid Hussain, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor,
86?
who submits that
86.
perusal of the case diary would be necessary and he would be able to bring the case diary day after tomorrow. The considering the submissions made by learned additional public prosecutor, let this case be listed on 17/7/2024 for case diary.
My lord.
Lordship.
It is the lordship.
Yes.
Yes. But in this case, I am behind the bar for 618 days. And by last order, lordship was pleased to call for the status report from the trial court. That has been received, my lord.
What is the date of your arrest?
My lord, I was arrested on 5/11/2022 and forwarded on the same date, my lord. Page 26 is the forwarding report.
Whether there are any other co-accused in this case?
Yes, my lord. One co-accused lordship was pleased to grant bail by order dated 26/2024, my lord. May I
Okay.
place the photocopy of from?
Who is Mangal Paul?
Mangal, my lord, he was arrested based on the confessional statement made by the accused who has granted bail by this honorable court, along with one Amrit Bahadur Chetri.
Where is the FIR?
FIR is at page, it starts from, my lord, page 14.
What is your submission?
My lord, my submission is earlier, my lord was pleased to reject his bail application, my lord, that I have annexed along with my application. Now, my lord, my only ground is that
Why it was rejected?
lordship rejected because that PW1 and PW4, I have annexed that their evidence, my lord, that there were incriminating materials against the present petitioner. So, my lord, my stand based on the judgment laid by the Tufan Singh was not entertained. No. Page 64, para 13 was specifically lordship has mentioned.
Okay. When it was rejected?
My lord, it was rejected on 3/4/2024, page 61.
Okay.
And my lord, the last witness was examined on in the month of March, 16th March 2024.
How many witnesses have been examined?
There were seven
Seven.
witnesses, seven
Out of
witnesses,
7, how many have been examined?
four witnesses, my lord.
Okay, what is your submission?
My lord, I have I am in custody for last 1 year, 8 months, 10 days, my lord.
And on what ground Azimuddin have been granted bail?
Hajimuddin lordship was also pleased to consider, my lord, length of detention.
Length of
Length of
detention.
detention. Lordship has, my lord, citing on various judgments of Honorable Supreme Court on the ground of length of detention, particularly paragraph 20 of the odd copy of order, my lord, which I have placed before this Honorable Court. My lord, when Azimuddin was granted bail, he was behind the bar for 1 year, 7 months, 14 days.
my lord. My lord, his
What
bill
was the contraband?
Contraband was cough syrup, my lord.
comes here more than 500 bottles, my lord.
Yes.
520 bottles.
Okay, yes, Mr.
My lord, here, first of all, Lordship may kindly pay the rejection order, my lord. That is 3/4/2024, my lord.
Yes,
Uh, Here, my lord, in the statement of the PW 1, 3, and 4, my lord.
incriminating materials are there again.
My lord, against the present petitioner, my lord.
Right.
And their role are different, their position, there may be from his position or not, that is different thing, my lord. But PW 1, 3, 4, I have also check mark, my lord. They have implicated the present petitioner, my lord, his involvement, my lord. And,
No, no, the rejection order,
my lord,
earlier
there-
rejection order was because they took the plea of Tufan Singh.
Two funds.
my lord,
So Tufan Singh, that the
Not
statement of co-accused,
my lord.
that plea was taken by the petitioner.
Not-
That
yes.
was rejected.
That
Rejected,
was
my lord.
rejected.
Now they are taking plea of prolonged incarceration.
My lord, here, my lord, I have gone through the my lord scan copy, my lord. Lordship may kindly see the my lord status report, my lord. Status report, my lord. It reveals that the trial is continuing, my lord, very friendly, my lord, accurately, my lord. And only 2-3 days PW was not present. And
Since March. my lord.
last witness examined on
PW4 was examined on 16.
16/3, my lord. PW
16.
234 examined on 16/3/2024, my lord. Only 2-3 days, my lord, PW was not present. And out of 7 PWs, 4 already examined, my lord. And from the evidence of my lord, PW 1, 3, and 4, incriminating materials are there, my lord, implicated the accused person, my lord.
Where do you stay?
My lord, I'm a resident of Karimganj, my lord.
And already,
Local person, my lord.
lordship already rejected after going through the my lord scan copy, my lord, PW 1, 4, 3, my lord, they have
Yes,
implicated the present petitioner, my lord.
rejection was on a different ground.
My lord. Their ground is a long incarceration, my lord, but in each and every case, my lord, my submission is that it is not applicable, my lord.
Okay.
And court below has rightly going, my lord, their duty, my lord. And only 3 witnesses are, 4 witnesses.
Yeah.
3 witnesses are yet to be examined. My submission is that at this stage, my lord, lordship may not grant, my lord. It will affect the, my lord, trial, my lord.
How many accused are there?
My lord, 3 accused persons are there.
How many are on bail?
My lord, only Azimuddin has been granted bail by my lord, by this honorable court.
Who else is there apart from,
One Amrit Bahadur Chetri, my
Chetri.
lord,
he is behind the bar?
he is behind the bar, and this present petitioner before the lordship. And my lord, Azimuddin was also granted considering the period of detention, my lord. The order which lordship has passed that deals with paragraph 18, 19, and 20, my lord, specifically deals with the prolonged incarceration part, my lord.
Okay, heard Mr. M.A. Chaudhary, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Mangal Paul alias Madan Paul, who is detained behind the bars since 5/11/2022, within bracket, for last 1 year, 8 months, 10 days, in connection with special NDPS case number 158/2022, corresponding to Bajari Chera PS case number 194/2022, under section 22 within bracket C/25/29. SFP of the NDPS Act, 1985, which is pending in the Court of Learned Section Special Judge Karimganj. Prior to filing of the instant bail application, the petitioner had earlier approached this court by filing another bail application, which was registered as bail application number 161/2024. However, by order dated 3/4/2024, the said application was rejected, mainly on the ground that the petitioner is not entitled to get benefit of observations made by the apex court in the case of Tufan Singh versus State of Tamil Nadu reported in 2021 4 SCC 1, as there are incriminating material against the present petitioner in the case record. Court para number 3 from bail application number 974/2024, dated 26/2024. Paragraph number 3, 4, 5. Learned counsel for the petitioner has submitted that on the earlier instance when the petitioner approached this court seeking his bail, he had prayed for bail on the ground that the statement of co-accused under section 67 of the NDPS Act, 1985 is not admissible in the trial against the present petitioner, and hence he should be granted bail, as the only material against him in the record is the statement of the co-accused recorded by the investigating officer during investigation. However, the prayer for bail was rejected at that time, as 2 of the 4 prosecution witnesses who are already examined in the trial, namely PW1 and PW4, have implicated the present petitioner. Stop. However, learned counsel for the petitioner has submitted that in the instant bail application, the petitioner has approached this court seeking bail on the ground of prolonged incarceration, as even after long incarceration of 1 year, 8 months, 10 days of the present petitioner behind the bars, the trial has not culminated, and only 4 out of 7 prosecution witnesses have been examined till date. It is also submitted by learned counsel for the petitioner that the last prosecution witness who was examined by the trial court was on 16/3/2024, and thereafter no prosecution witness has yet been examined. Code para 9 from the bail order. Learned counsel for the petitioner has submitted that detention of more than 1 year, 8 months, 10 days of the present petitioner in the instant case is long enough under the under the facts and circumstances of this case, which would override the embargo of section 37 of the NDPS Act, 1985. Code para 11. Code para 12. Code para not 12, code para 13. On the other hand, learned additional public, Mr. B. Sharma, learned additional public prosecutor, has vehemently opposed the grant of bail to the present petitioner. He has submitted that the prayer for bail of the present petitioner on an earlier instance has been rejected by this court after considering all the materials. And as apparent from the said bail order, as apparent from the bail order dated 25/6/2024, passed in bail application number 1838. No, sorry,
1/6.
which is the rejection order.
Earlier bail application number
161 of 24, which is rejected.
161 slash bail order dated 3/4/2024 in bail application number 161 of 2024. The PW1 and PW4 have deposed, have implicated the present petitioner. Learned counsel for the petitioner has learned additional public prosecutor has also submitted that the trial of the NDPS case number
158 of 2020.
158/2022 has been progressing properly, and already 4 of the 7 listed witnesses have been examined, and only on 4 occasions since 16/3/2024 the prosecution
Right.
witnesses have remained absent.
Four occasions.
4 occasions. Learned additional public prosecutor has submitted that the remaining 3 witnesses would be examined very shortly, and if the petitioner is granted bail at this stage, it would derail the trial
My lord.
which is pending before the learned trial court. I have considered the submissions made by
Moreover, section 37, my lord.
stop. Learned counsel for the petitioner has also, learned counsel for learned additional public prosecutor has also submitted that in the instant case, total 520 numbers of bottles of 100 milliliter each of cough syrup containing codeine phosphate have
Right.
been recovered. And considering the huge quantity of
Commercial company.
contraband which is recovered, which happens to be commercial quantity, the embargo of section 37 comes into play. And therefore, he opposes the grant of bail to the present petitioner. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record, including the scanned copy of the case record of special NDPS case. No, sorry, including the up-to-date status report of the special NDPS case number 158/2022 received from the Court of Learned Special Judge Karimganj. Code paragraph number 17, 18, 19, 20. Under the facts and circumstances of this case, as discussed herein above, and in the light of observations made by the apex court, this court is of considered opinion that though the bail application preferred by the present petitioner was earlier rejected on the ground of non-applicability of the
Judge.
observation made by apex court in the case of Tufan Singh versus State of Tamil Nadu to the case of present petitioner. However, the fact remains that even after long detention of 1 year, 8 months, 10 days of the present petitioner behind the bars, the trial has not culminated. And such a long incarceration of the petitioner, in the considered opinion of this court, outweighs the embargo of Section 37 of the NDPS Act, 1985. And hence, this court is of the view that he is entitled to get bail on the ground of prolonged incarceration only. More so, when one of the co-accused who is facing trial along with the present petitioner has been granted bail on the ground of prolonged incarceration. Stop. Court paragraph number 22 with necessary changes. With naam change kore debi. 50,000 with 2 sureties of like amount.
One may be government, my lord, government service.
Deputy Civilian, my lord, like Azimuddin, he is appearing, my lord.
There is-
Lordship directed him to appear, my lord. I have the order. Because last fixed term,
Okay,
my
no,
lord,
same to Azim.
My lord.
I'm DPO.
Yeah, Lordship, my senior legs in the other court. Can you
My lord,
proceed?
there CD not received, my lord, they are interim, my lord.
You are on interim.
My lord.
My lord,
Heard, Mr. What is your name?
S. Kashyap on behalf of NJ Das.
Heard Mr. S. Kashyap submitting on behalf of Mr. N.J. Das. Also heard Mr. B. Sharma, learned additional public prosecutor, who prays for some more time for
Fine.
producing the case diary. Prayer
Fine.
is allowed. Let this case be listed again on
My lord, second, my lord.
2nd of August,
My lord.
2024.
So, Lordship.
The interim order shall continue till next day. None appear.
None appear.
It is there
CD is here, my lord.
day after tomorrow.
My lord.
None appears for petitioner on call. List this matter on 17/7/2024. The interim order shall continue till next day.
My lord.
The case diary shall be retained till next day.
CD was called for. My lord, here also CD not received, my lord, they are interim, my lord. From North
Mr.
Lakhimpur, my lord.
H.S. Bora, learned counsel for the petitioner, also had Mr. B. Sharma, learned additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. Let this case be listed again on
6th, my lord. 6/8
of
August, my lord.
August
August?
2024. The interim order shall continue till next day.
Right.
My pleasure, Lord.
It is wrongly mentioned as part.
Pardon, my lord. We have also verified, my lord, in the morning.
It is not part.
Not pardon, my lord, it was fresh.
Lordship, first one submission is Lordship and Learned Senior Advocate A.M. Bora was earlier engaged. And now he is not longer Lordship in this case. And my Lord, and his three numbers of juniors were, their name is shown in the first list, Lordship. Their name may be struck out, Lordship, and they will not proceed this case further. And
Now,
Lordship,
what is your submission?
and first submission and Lordship, now Lordship, I is there, the appeal is pending, Lordship. And Lordship, and prayer for bail, and Lordship, and since the date of arrest, Lordship, and he was in custody.
No, 389 was earlier rejected.
Rejected, Lordship,
Rejected, no.
last year, Lordship. In the month of November.
Then on the same ground, how it is?
No, Lordship, Lordship, and here in this case, Lordship, I will argue this case, Lordship, and if time permits, Lordship, and otherwise, Lordship, and all the, there are say 8 numbers of witness, Lordship. There are sufficient discrepancies of their statement. SIP and examination, SIP and cross also, Lordship. And even then, Lordship, the informant, and he is also
No. What I am,
Lordship, and another Lordship, and
whether are you pressing 389 petition or you are going for
My lord, whole, my lord, whole.
final appeal?
Lordship. And Lordship, and once annexure is page number 93. The IA Lordship, and during his custody, during his in jail, Lordship, and one child is born now, Lordship, and he is about 4 years. And Lordship, and
No,
and,
you go
this-
for final hearing if you have any merit. Because that was the observation.
My lord, observation in the last order also,
In the
my lord,
last
that due
order.
course, my lord.
Lordship, only for few days, Lordship, interim protection, and maybe Lordship, only for few days, Lordship, maybe grant Lordship.
For
Only
what?
For he will. Lordship, and his father is also Lordship, and sick person, and his 4-year child, about 4 years, Lordship. And he, while he was in the custody, Lordship, and his child was born. And
This was
and-
not the ground, my lord, in the
and
NDPS case.
Lordship, and
my lord.
this is
No,
the psychologically and mentally trauma of the child, Lordship, and on that.
No child can meet the
Lordship,
no. My lord, there is
Father in
no
jail.
problem.
Jail, Lordship, that
you
cannot.
go for final hearing
My lord.
And if possible,
because
Lordship,
that was the
My
observation.
lord, in the last order also, my
You
lord.
may make a prayer for
I have-
expeditious hearing
I have observed this order, Lordship. But
because
only for
your
few days,
389 does not have merit.
and
389 without hearing you, if you can convince that is otherwise, after going through the petition, it appears that it is repetition.
My lord, of the earlier, my lord.
Earlier.
Lordship, there is the provision is there, Lordship. We have the right to find, Lordship. And if observed
but-
only for 15 days, Lordship,
Yeah.
can it be grant, Lordship? That because since the FIR is lost in the year of 29/3/2022, and on the same day he was arrested, and subsequently.
No, now what is your submission? Are you hearing on merit? Or are you pressing this petition?
Lordship,
Because I am not inclined to
No,
grant it,
and 389,
389 petition. Because earlier petition was
Rejected.
rejected.
rejected. After going to the.
You have not made a
Leave lordship, I remember we put
No.
lordship. Otherwise, lordship only for 10 days or 15 days and if possible, and he will surrender lordship, local person. And he is residing within the jurisdiction of this court, trial court. Permanent resident, and even then his father is
madam,
a
that is-
government.
uh,
Let me finish. And otherwise, his father is a government employee lordship, and so there is no any condition lordship, and he will appear, only 15 days may be granted lordship.
In NDPS cases, that too for commercial
But-
quantity of contraband.
And even then lordship, and one merit lordship, I just one submission lordship. And he is the driver of the vehicle lordship, and the owner of the register owner was different person. And
No,
during
that aspect has been
some lordship and the
considered in the,
So my humble prayer once again, lordship, and if 15 days lordship, only 10 days or 15 days, and he will surrender lordship, any condition.
no.
And even then lordship, and they are residing in a in a erosion area lordship, and a heavy flood is also going on. Only for any condition lordship, and he will surrender. Any condition lordship, if lordship. My humble second. 15 days will surrender.
Arveda, yes. Then I'm rejecting it.
Have to leave.
Heard Mr. F. Hawk, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 489 of the Code of Criminal Procedure, sorry, 389 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, has been filed by the applicant, Monser Ali, praying for suspension of the execution of sentence passed in the judgment and order dated 1/3/2023 in special NDPS case number 14/2022 by Special Judge Gwalpara, whereby the applicant was sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 1 lakh for the offense under section 22C of the NDPS Act, 1985, with default stipulation of rigorous imprisonment for a term of 3 years in the event of failure to pay the imposed fine. Learned additional public prosecutor has pointed out that the present petitioner had earlier also preferred an present applicant has earlier also preferred an application under section 389 of the Code of Criminal Procedure, 1973, in the connected appeal, that is criminal appeal number 130/2023, which was rejected by this court by order dated 21/11/2023. Observing 2023, stop. I have considered the submissions made by learned counsel for the applicant has submitted that the present applicant has been detained behind the bars since
Since 29/3/2022.
29/3/2022. And he has a 4-year-old child and who was born while he was detained behind the bar. And to meet his child, it is prayed that he may be granted at least 15 days interim bail in this case. It is also submitted that his family is suffering due to flood. Learned counsel for the applicant has also submitted that the applicant was the driver of the vehicle. And he was not in conscious possession of the contraband which was seized in the case. On the other hand, learned additional public prosecutor has submitted that the plea taken by learned counsel for the applicant on merit was earlier considered by this court while considering interlocutory application number 498/2023. And after due consideration of the pleas, the prayer for suspension of sentence was rejected. As regards the other pleas taken by the learned counsel for the applicant, learned additional public prosecutor submits that as the present case involves commercial quantity of contraband, hence it may not be appropriate to suspend the sentence imposed on the applicant at this stage. More so when his earlier application for suspension of sentence was rejected. Stop. I have considered the submissions made by learned counsel for the tribal parties and have perused the materials available on record. It appears that after due consideration of the submissions of the counsel for the applicant, the earlier application under section 389 of the Code of Criminal Procedure 1973 filed by the present applicant was rejected as this court found nothing glaring or apparent on the face of record which may prima facie lead to the satisfaction that the conviction of appellant may not be sustained while rejecting his earlier application for suspension of sentence. The petitioner has not made out any different case, and he has the plea raised by the petition applicant, learned counsel for the applicant, were considered while rejecting his earlier application also. And the new pleas taken by the learned counsel for the petitioner, in the considered opinion of this court, does not justify suspension of the sentence of the present applicant, considering the fact that prima facie there is nothing on record at this stage which would lead this court to an opinion that the sentence imposed on the applicant may not be sustained. Hence, stop. As the quantity of contraband seized in this case was commercial quantity, Section 37 of the NDPS Act, 1985 is applicable even in the case of an application under Section 389 of the CRPC. Stop. For reasons discussed herein before, this application for suspension of sentence of the applicant is rejected. The petitioner, the applicant may, however, be at liberty to make a separate prayer for out-of-turn listing and expeditious hearing of the connected appeal.
Right.
With above observation, this interlocutory application is hereby disposed of.
And Lordship, my submission is Lordship and earlier advocate Lordship, their name may be struck out Lordship, but they are not pursue this further.
No, here the name, your name is there, F. Hawk.
But Lordship, it is something
Senior
difficult,
advocate.
they are
Senior advocate's name is not there.
Lordship is there, Lordship, and in
In
appeal.
second, in
appeal-
second, in IA not here.
I is also and another one, C. Bhagavati. So my lord, they are not longer in this case, Lordship. So sometimes it is,
No, but they should,
My-
even
my
they should
lord,
come and say
My lord, that is.
that we are
that
not
is.
longer.
Lordship.
They should come and
like-
say that we are not longer.
NOC is there, Lordship. Yes, and it without NOC as a.
Because even if their names are there, you can make your submission because your name is also there.
There, there.
Your name is
But
also-
we are, normally Lordship, it is happening sometime Lordship. And it
But
is.
they should come and say that we are no longer.
longer.
Yeah. Problem is there.
No problem. Is
In main case, learned counsel for the Mr. F. Hawk, learned counsel for the applicant submits that the earlier set of counsels led by Mr. A. M. Bora, senior advocate, is no longer representing the appellant in this case. And to that effect, he has submitted a no objection certificate on behalf of Mr. A. M. Bora, senior advocate, submitted by Mr. Bipul Bhagavati, advocate. Let the no objection certificate be kept in the record of Criminal
Yeah,
Appeal
so-
number 130/2023. Registry shall not reflect the name of Mr. A. M. Bora and Mr.
B. Bhagavati,
B.
C. Chaudhary.
Bhagavati,
C. Chaudhary.
C. Chaudhary, and V. A. Chaudhary.
C. Chaudhary and V. A. Chaudhary in the cause list henceforth.
Lordship. Obliged, Lordship. And Lordship, and expeditiously, and date may be given for hearing.
For
No.
that, you have to make a prayer.
Hmm.
You
For
have
IA.
file an IA.
IA.
Lordship,
For early hearing.
Lordship. Obliged.